All right. Well, thanks so much for joining us for another episode of the Profit Minded Business Podcast, where we come together as small business owners and other service providers to really, take advantage of a community of knowledge and become each other's brain trust, in effect, by coming here talking about pitfalls and successes and, things that we can all grow from. We all benefit from talking to one another in casual conversations, and we felt like we really wanted to provide that in an open stage like this. So thank you guys so much for joining us. Today we've got Jeanne Bynum Hipes of Hipes Law, who is an employment attorney of a lot of experience, just a wealth of knowledge. It's just been fantastic to have you join us today. So many issues around this that we want to get into today. And of course, we're joined by the lovely Lynn Spencer of Killingsworth Spencer LLC CPA. And she's, obviously somebody that if you have any tax concerns, that are going on, and you don't have a tax planner, obviously you want to listen deeply to what she's going to talk about as well. So thank you both so much.
And who are you?
Oh my gosh, I always forget to introduce myself. So I'm your host, Corbin Cook. I'm with S&B Strategy Consultants, and I function as a fractional CFO for small businesses, as well as helping them plan for their overall retirement. I'm also part of a group called Auxilium Associates, which is really expands on the fractional CFO and brings in the full fractional executive leadership team. And so it's a great opportunity for small business owners to take advantage of experienced talent without having to pay the full price for everybody. So anyway, thanks again for joining us. Jeanne, tell us a little about your story and how you became Hipes Law.
Oh, wow, that's a long story. You want the abbreviated version? First I went to law school at University of Virginia. Out of that, I came to Atlanta to become a lawyer and got a significant background in first insurance defense for a couple of years and then commercial litigation for a number of years. And then I was recruited by Lockheed Martin to go to their New York office, and I was in-house counsel for them, assistant general counsel at Lockheed Martin for a couple of years. And then I came back to Atlanta, my hometown that I've adopted, actually. I'm originally from Virginia, but I've adopted Atlanta. And I worked for an employment law firm, and I learned lots about their practice and employment law in general. So I had an accumulation, I'll say, of employment law and commercial litigation experience. And in the commercial litigation context, there are pockets of employment law. And so at some point, I just decided, you know what, I can do this myself. And so I formed Hipes Law, and I've been doing it vigorously ever since. Well, I wish somebody had trained me for new business ownership, because nowhere along the line does anyone train you, although I had watched multiple businesses operate. So I knew good practices from them. Some places have good practices, and I've seen what works and what doesn't work. But I am surprised a little bit at how much running the business takes of your time. It's, you're used to doing just law practice, and that's quite time consuming all by itself. But running a business is like a whole nother job. It's like two jobs in one. So that was more than I was expecting, but I'm glad I did it nonetheless.
Yes. It's a surprise.
Surprise!
Surprise. Well, that's great. So, Hipes Law focuses on the employment arena. Tell us a little bit about your focus now, and who is a typical customer client look, for you?
We actually represent a lot of high-level executives and others, sometimes managers of various size corporations. A lot of our clients have come from large corporations, and so we're always dealing with the big firm counsel on the other side. Our focus is when if someone has been terminated, for example, high-level executive is terminated, often they get a severance agreement, and we review those. And they often have provisions in them that are like non-compete provisions, which prohibit them from going to possibly a company they would like to work at next. It's a difficult position, no matter who you are or what your job was, to be terminated. So we work with people to see if there are things that happened in their termination or in their employment that are actually illegal. And we see if those are bargaining chips possibly to get a better severance. So we negotiate severance quite a bit, but and we try to resolve people's employment issues. Whether you're still employed or whether you're not, we can assist you with employment issues that come up. Discrimination is a large issue that we deal with frequently. Age discrimination is a large issue. There's rampant age discrimination. We also are working a lot right now with disability discrimination, but we also do sex discrimination, national origin, race. All those forms of discrimination often creep up in employment situations, and we identify those. We know what's legal, what's not legal, typically, and if we don't, we know how to research it. But we deal with all those kinds of discrimination and whatever else might be illegal happening in a relationship. Breach of contract is another area that we do extensively in that kind of environment. But
so when you're talking to somebody who's gone through multiple interviews and they just feel like, whether it's from their disability, or let's just talk about the disability subject, how do they prove some sort of a bias or a discrimination?
It is hard to prove. I will tell you, in an interviewing situation especially, because you don't have access to a lot of information. Any kind of discrimination can be proved by circumstantial evidence. You don't have to have direct evidence, and you hardly ever do have direct evidence. Sure. But from circumstantial evidence, so for example, if the person who was interviewing found out, that, say they were disabled, and of course the employer hired somebody who wasn't disabled. Well, that doesn't seem really strong offhand, but if you couple it, say, with the fact that perhaps the interviewing disabled person had multiple degrees that were more appropriate than the person that they hired, or other qualifications that would have made them the better candidate. But the problem when you're interviewing, it's hard to know whatever happened. Who did they hire? Yeah. What qualifications did they have? Sure. So it's a difficult process to bring an action for failure to hire appropriately, or discrimination in the form of failure to hire. But that doesn't mean there isn't discrimination that goes on out there, and the employer can avoid discrimination claims by making sure that they are evaluating evidence or the job candidates' applications without considering the disability. If the person can show that he can do the job, he or she can do the job, that shouldn't be a consideration.
And so I think a lot of times a small business owner may just shy away from someone with a disability if they're prompted to do that in their mind, but they're doing it because of the unknown. Right. They're not really doing it because they've thought through what it's going to be. They just think maybe it's, I don't know what they think, but can you just kind of speak to, play out the scenario where they do hire someone with a disability and it comes out great because they didn't have that discrimination in their mind. They didn't have that bias that this isn't going to work out for us. And they took a little bit of extra time to have a brainstorming session, kind of in what we discussed. Tell me what it looks like for someone to do it the right way.
Well, first of all, I should preface my statements by saying that the American Disabilities Act, as amended in 2008, only applies to people who are businesses that have over 15 employees. So that immediately cuts out the really small businesses of course, everyone should treat disabled people fairly, but as far as the law goes, the American Disabilities Act only applies to people or to businesses with 15 or more employees. But if you are
Okay, back up on that. Is that because? Why is that?
there's different size. Congress, in its wisdom, has decided that only certain size companies should be liable for certain things, and discrimination under Title VII, like race, sex, other kinds of discrimination, only applies to 15. And then, for example, like FMLA, Family Medical Leave Act, discrimination also happens. That's another thing we do in office, see that in conjunction with disability. But that requires 50 employees. So you're not the smaller businesses are not dealing, say, with that issue. Or the ones under 15 employees are not dealing with several of the issues. I mean, when I say not dealing, that doesn't mean they're not dealing. It's just under the law. That's when these laws that protect, say, disabled people or other people in what I call protected categories of race, sex, national origin, they aren't having to fear the law with regard to those areas. And a lot of people do not know this, but there's different levels of employees for several different laws. Sometimes it's 50, sometimes it's 20, sometimes it's 15. But to do it right, back to the original question, I believe, you want to, if you're an employer, if you're interviewing someone, that's different than if you have them already. May I give that example? If you have a disabled employee already, they need to ask you, the employer, that if they need an accommodation to do their job better. Say they have a vision problem that's so severe that they really can't do it unless the lighting is adjusted or their screen on their computer is bigger or something like that. When the process is that when an employee asks for an accommodation, the thing that every employer should do next, but that they almost never know to do this, is have what's called in law an interactive discussion with the disabled employee. And all that is a brainstorming session. How can we work this out so that you can do the job we need to do if we just do something that's not causing us an undue hardship, but if we just adjust the lighting, we give you a bigger screen, or we let you come in late, say you have to take medicine that is such that you just cannot make an 8 o'clock start time because of the medicine and when you have to take it and all that. Sometimes, an accommodation might be, okay, you can come in later. Or you can have off, or you can come in late because you have to go to the doctor once a week at, whatever time. Whatever it is, as long as it doesn't cause an undue hardship, and that's a legal term, which is the source of much litigation, you should be able to make that accommodation to help the person who is disabled fit in, get their job done. The employer, get what you want, which is somebody who can do the job. And so many people are excluded because there's a non-understanding of what an employer's duty is. So people who have disabilities or become disabled while they're on the job get fired a lot, which is a terrible thing for a disabled person anyway. It's hard enough to work, but then to find another job, with a disability is very difficult.
If it's a recent disability, the emotional stuff you're going through dealing with the new world. So if the employer is on board to go through the interactive session, do they need to document the interactive session?
Yes. Oh my gosh, yes. That is the mantra we preach nonstop. Document, document, document.
And what does that documentation look like if they wanted to do it the right way?
Well, they would certainly need to document the fact that the employee ask them for accommodation and state what that is. They would need to keep records on such and such a day, and they could do this by email to the employee also. Anything that documents the process that went on. Say, we met and we discussed your request for an accommodation of whatever it is, and we discussed it extensively, and we determined that we can have an accommodation of such and such, whatever it is, but we can't have an accommodation of this other thing, the thing that you asked for, possibly, because that creates an undue hardship for us. And that undue hardship is it would cost us thousands of dollars a month to maintain what you're requesting, or whatever the situation is. But gosh, document. It's so important to document.
And in that,
How long do you have to keep those documents?
Yeah, go ahead.
Oh gosh, keep them as long as you can have a lawsuit, certainly, and maybe even longer than that. And it depends on the statute of limitations for disability. Oh gosh, I'm not sure off the top of my head what it is, but it might be 4 years. You would certainly want to keep records, your business records anyway, for quite a number of years. And there are charts you can find out there that for this you have to keep the records X years. For this you have to keep the records Y years. And there's just a whole variation in how long you need to keep records for various circumstances, including taxes. And Lynn, you probably know that. Yeah, I would keep them. You certainly want to keep them as long as the statute of limitations is that you're dealing with. So for some claims it's 2 years, for some claims it's 4 years, some claims it's 6 years. But even after the statute of limitation has expired, I would recommend keeping them for a couple of extra years just in case something arises from the past. See, you think something's over and done with, and sometimes it's not. So it's just a good idea to be cautious in what you keep.
And as far as how subjective is the undue hardship clause for a business owner?
Yeah, that is the objective. That is how they would get out of hiring somebody or accommodating somebody who had a disability and requested accommodation.
So they want to do the right thing. They have the interactive discussion. They document everything. They have a very productive conversation. Comes out what's required is really something more than the owner can afford to do. And so now that the owner is now aware that the disabled person has limitations that maybe they didn't disclose originally because of this concern that it would cause a problem, now the owner is aware of it, and the undue hardship prevents the accommodation.
Well, in that circumstance, that first of all, that is a risk, but the employer should definitely document how they came to that decision. And they can do that through email as well if they want to, or just keep records that I met with this one, and this one in the company, and we looked at the issue of accommodating in this particular way, and it would cost whatever, $100,000 a year to do this or whatever. We just cannot do this. And so that would need to be conveyed to the person asking for an accommodation, saying, we appreciate your talking with us about it, and we've thought through, but to do what you've asked us to do, we just cannot, because it's going to cost so much. It's cost prohibitive. And so at that point, if you're still having an interactive discussion, which I would recommend, is it could be that in the brainstorming process, if we can't do this, well, there might be something else that's not cost prohibitive that could be thought of in the process of discussing it, such that an accommodation could be made still that allows the disabled employee to do the essential functions of his job, which he must be able to do to stay employed. Okay, so if you can't do the essential functions of your job with or without accommodation, then the employer has no choice but to find somebody who can. I mean, that's the whole purpose of employment.
That's why it's a job. It's something I was thinking about is, and the idea here in this conversation is to promote business owners doing things like this, because it's less work than they realize. to have these conversations. And the reality, I think, is that if you try to replace an employee, there's a cost to doing that.
There absolutely is.
Can you talk about that and what your experience is with, I'm not going to throw out numbers, but it's expensive.
It is expensive to train or to retrain or train an employee to any job. I mean, and the more complex, the more expensive it is. And plus, when you lose an employee, the value that they have as a result of being very familiar with your business, familiar with your clients, familiar with your processes, the way things work at your firm. And, so you don't want to be losing employees if you don't have to. So, if you can work with an employee, in some way that does not cause undue hardship, my goodness, why would you not?
Another side note or another thing to point out is that oftentimes you want your employees to treat the business as though you would treat it. You want your employees to be, you want them to act like owners, right? And so I can only imagine that going out of your way to, even if the disabled person has not brought it up, to engage in, hey, is there anything that we could be doing to help you, right? To even engage like that, because if I was a disabled person, I would be nervous that it would cause a problem with or even expose more of a limitation than I really subjectively have, right? That I'm getting the job done, but maybe if I bring it up in a light that then causes me to have to answer very direct yes, no questions about it, that maybe I could then be exposed as not being the best candidate and therefore lose my job.
It's a scary process,
right?
No doubt.
So maybe if the employer was willing to initiate that engagement, you would have an employee that would value that relationship, that job, that business so much more. I mean, that much more committed. So not only do you save the time and effort in hiring someone new, but now you've got an employee that is like
committed to you, because they do so appreciate that you're willing to work with them. They're very conscious typically that they have a disability, and to have an employer work with them with respect to that is usually so appreciated and makes them more loyal than ever. And it could be talking about accommodation. Sometimes the employee is supposed to ask for the accommodations, but sometimes things will be considered asking, even if it isn't just like, I have this, could you do that? It's just like, I can't make it to work because I have this medicine that makes me just pass out until 10 o'clock in the morning. Do you really have to have me here at 10 o'clock in the morning? That wasn't, I have a disability, I need an accommodation. It was telling the employer their circumstances. And, if you are a regular person without, any impediments to this process, but you could just realize you would, and may be held accountable legally to realize the person needs an accommodation, even if they didn't come out and say, I must have this accommodation. They told you their circumstances, and a normal person would realize, oh, well, you need to come in at 10 now. Can we do this? So they don't have to even use the word accommodation. It's not required. So.
Okay.
What can you tell us about age discrimination as somebody being on the back half of her working years?
Well, I hate to tell you that age discrimination is rampant. Of course, we are in a firm that deals with age discrimination, so we see it more frequently than the average person probably, but we do see a lot of it. And we see all kinds of efforts, I guess, sometimes, but especially by larger employers, to sort of encourage people out the door when they're in their 50s. And the age at which you are protected under the law is a shockingly low 40. Once you are 40, you are in the protected category of age discrimination, and they cannot hold your age against you in making employment decisions. So
how does that even get proven, though? I mean,
it's by circumstantial evidence. That's why it is a challenge to prove any kind of discrimination, because like I was saying earlier, you don't normally get direct evidence like Oh, well, now that you're 50, you should think about retiring. When are you going to retire?
But that in itself right there is age discrimination.
Yes.
40's the new 20. So
40 is the new 20. Yes. But it hasn't rolled over to the age discrimination laws yet. 40 is the age discrimination cutoff, where at that point you are protected thereafter.
So we all know 40 is young.
Right. We know that. Absolutely.
But if you have an employee you want to let go of who's like 43, do you have to be concerned that they're going to bite back?
You want to think about that if you're large enough to be covered by the Age Discrimination and Employment
When really
Act.
we all know that it has nothing to do with his or her age. But
Well, it depends on the circumstances surrounding their termination. If, for example, for months people are saying to the employee, this is really a young person's job. You gotta work long hours. I can't imagine that you don't want to work long hours, do you? I mean, you're 40 something, right? I mean, I don't. There's just all kinds of little circumstantial evidence, like, oh, you know what? We really need a 21-year-old in your position. They can do the same job you do, and it's really less expensive for us, and I don't really think we need somebody who's your age. Or, you think that's outrageous. No one would say that, but you'd be amazed what people say out there.
So someone who gets told that, I mean, how are they recording it, and then how is it actually something that they can use in a legal matter?
Well, I'll tell you, people ask that a lot. And I have a lot of people that come to me and say, oh, I have no case because it's he said, she said, they'll say this, I say that, whatever. But the reality is that your testimony is evidence. And credibility will determine how that evidence is viewed sometimes. And if you get to a jury, for example, and you say one thing and the employer says another thing, and the employer comes forward in a wolf suit and you're in your sheepskin, you're going to be perceived differently, and credibility issues can be very determinative in the outcome of a case. But if you have evidence, I said to him this, and they said to me that. I said, I'm planning to work till I'm 70. And they said, you know what, we need a 20-year-old in this job. That's an extreme example. But people do all the time say, when are you going to retire? I had a recent case where my client was given a document that says, you are retiring today. And this is a very virile, healthy, very accomplished, very intellectually astute gentleman who was handed that. He planned to work there till he was 70, but they told him, you're 62, okay, you've done enough, you're retired today.
Wow. Okay, so what, assuming that's the circumstances, what is someone like that entitled to after they approach you and begin the process of litigation? Like, what is the end result for somebody who decides to go through that?
Well, damages are what we call the end result. That's money. And, of course, if you've been fired, you need money. And a lot of cases are settled, but some are not. And in those cases, you have to go ask the jury for money. And the law specifically provides what damages those are. And those include, for example, back pay. What if it's been 2 years? You've been out of work. You got nothing. All the salary, promotions, interest, everything that you would have gotten had you not been fired for a discriminatory reason, you get that back. Another very important component is if you can't go back to your job, which a lot of people could not or would not given what's happened there, they can get front pay. And front pay is a very interesting concept. Front pay is how long the court thinks it will take you to get back up to where you were, And
sounds like alimony.
well, kind of. It's sort of that concept, but it's a great thing because courts hold kind of all over the place about how much front pay a person can have because it's very fact specific But there's this one case that we often quote. It's a case from Alabama, which is in the 11th Circuit, which is our judicial district here in Georgia. It's Georgia, Alabama, and Florida are all in the 11th Circuit. And in that case, there was a young lady who was 33 years old, and she worked for the county commissioners. And something happened, and she made a discrimination claim. Well, they fired her. And so they went to trial on this, and just on this issue, she said, I was planning to work there till I was 65 years old, and I was going to retire there. And guess what? The judge awarded her 33 years of front pay. No. Yes. Wow. And how does front pay determined? Front pay is like how much you would make with the amount you actually did make or could make taken out. So, for example, what if the only jobs in town were gas station attendant jobs and you got one of those for $10 an hour? Yeah. But the job that they fired you from was $40 an hour. Well, you'd have to take off that $10 job an hour because you could still do that, you know. But who wants to? I mean, you know. But anyway, she did get awarded 33 years of front pay, which is awesome, you know, from a plaintiff's lawyer's perspective. From an employer's perspective, it's, oh my gosh, oh no. But like I said, awards of front pay are kind of all over the place and run frequently from like 2 years to 4 years. That's a fairly frequent amount, sometimes much more.
Now, do you have any kind of resources for a small business owner that wants to make sure they're on the up and up and doing things right, saying things right, treating people with respect? Is there something they can do to reach out to you or even just go to a website or something and pull some information?
We do have some information on our website, which is hipeslaw.com, HIPESLAW.com. But they can always schedule a review with me if they have things they're concerned about. I do charge hourly, and we do talk to business clients as well as employees. I have decades of experience in the business representation world. So they can just come and talk to me anytime. Call me up, 678-867-7006, or write me, counsel@hipeslaw.com. And we are happy to schedule an appointment to discuss whatever concerns them.
Seems like someone who's over 15 employees or getting near that point needs to reach out, and then someone who's at 50 for sure should have already reached out to somebody.
Absolutely, by now.
Yeah, by now.
I'm hoping.
But if they feel like that they need a refresher, it sounds like you're the person to talk to.
Right, absolutely. From both the business perspective and the employee perspective, even if they're still working and they have issues or concerns, it's really good if they come see me while they're still employed, because I can help them while they're employed. And then they might not get fired, maybe. Right. And from the employer's position, if they have somebody they're unhappy with, for example, and they say, oh, they're doing this, they're doing that, and I'll just look at the whole circumstance and I'll say, well, if you need to terminate this person, you need to do it this way, and document. That's our motto here, because that if you come to me, you might not get sued.
Well,
you might not.
That's the key.
That's the thing. That is the thing. Nobody wants to get sued.
Right.
So if you can do things, if you know the law, first of all, so many times people don't know the law. If they can come to me and tell me their concerns and what their business is like, I can educate them with respect to issues they need to be concerned with and processes that they could undertake to avoid those concerns.
Sure. It seems like it's worth the time and effort to have those conversations before something unravels on you.
I think so, definitely.
Well, thank you for that so much for being here.
So,
Lynn,
I have one really
on...
quick question for
please.
Jeanne, but I know the answer because I've known her for a number of years and I've heard her speak multiple times. Are women or older people the only people protected?
No, there's a number of people protected, actually, but women are protected. Men are protected as well. It depends on the circumstances. On the basis of sex and certainly age, but people think maybe women are protected, but men aren't. Oh, men are protected too. We have men clients, as a matter of fact, who have discrimination claims because of the environments they're in. For example, if they were in an all-woman environment and they were treated differently and worse than the women because they were male, that would be the same kind of claim as a sex discrimination claim for a female. The sex discrimination laws work both ways. And so, race discrimination is the same, age is age, but age can be relative also. For example, if you're 40 is the cutoff in the law, but say you are replacing a 65-year-old with a 41-year-old. That disparity in age there, even though the person doesn't technically qualify as being outside the category of age protection, that can still be a discrimination claim. The disparity in age can be considered.
Something else that we talked about, now that we keep one more question. So when somebody, an employee, files against an employer, and this is something that we talked about just briefly, but it does actually, it is on their background check going forward.
I'm glad you are giving me the opportunity to clarify that. When you say file, it depends what you mean. You can file with the EEOC, which you have to do if you're making a discrimination claim. They're like the gatekeepers to the court system on discrimination issues. Have to first file with the EEOC within 180 days of the occurrence of the discrimination. So that's an important deadline to remember.
6 months?
Yes, it's 6 months. And then you have to get a right to sue to go further. But it's now I'm going
the
astray.
background check is only if they actually went to a lawsuit,
right?
Not if it's filed with the EE.
The EEOC is confidential. The employers in general who are out there doing background checks cannot find out whether someone has filed an EEOC claim. But once you get to court, everything is public record, everything. And so if you have sued your employer and you're trying to get a job with a new employer, that suit against your employer will very likely be found on a background check. And obviously that will cause problems because many employers will be immediately afraid to see, this person has sued their employer. Maybe they'll sue me next. And that thought process is rampant, and they aren't going to find out how justified your lawsuit was or how horribly you were treated in violation of the law that justified the lawsuit.
Right. So, and we even discussed, how does a applicant who is finding themselves going down the interview trail, everything's going well, everything's going fantastic, and all of a sudden the employer just kind of vanishes on them. We talked a little bit about, maybe it makes sense for that, the applicant to, at some point in that process, assuming their litigation wasn't just spiteful, give some sort of, bring it up and have a conversation about it so that it doesn't get to the point where all of a sudden someone else has their spot, even though they were a great candidate.
Right. Well, that is a subject most candidates don't want to talk about to a potential employer. But the reality is, if they're going to do a background check and they're going to find that you filed a lawsuit, it's generally better for you to bring it up before they find it. That's just the general rule in a number of things. Better for you to bring it up than for them to find it. Because once they find it, they may not talk to you about it. But if you bring it up in an interview, and it's very tricky, and I realize it's uncomfortable, but you just have to realize that if they find that lawsuit, they won't come back and talk to you probably and say, hey, you sued your employer. What's the deal?
And you're like, you know what? I don't like the sound of that, so I'm not going to hire you now. It's not going to happen that way.
That conversation isn't going to happen. You just won't hear from them. Like, there's lots of employers that you never hear from. how can you then prove it was because you filed a discrimination lawsuit that they are not hiring you? It's hard to prove. It's not impossible, but it's very hard. Right. So it's better to help them understand up front, I would think, rather than have them discover it in a background check.
And even at that point, again, it goes back to having a loyal employee. Sometimes, whether it's disability, whether it's something in their background check, if you're willing to have that conversation, then, or especially if they bring it up anyway, to understand that person, understand their circumstances, and value that person for the value they bring to the team, and not just for the potential lawsuit or the potential extra work from a disability standpoint. These employees are going to be fantastic employees, assuming they fall into all the other good candidate qualifications, because when you have an employer that believes in you and fosters a culture of support and bringing everyone together to accomplish the business goals, and everyone feels like they're a part of that, you create a wonderful employee culture that will transform how your business succeeds because of that culture.
That is so true. That is so true. I can't tell you how important communication is in what I've seen happen in businesses and with employees. That's if adequate communication could have resolved way before a lawsuit started. Right. Way. And it's such a better culture all the way to be heard and to be able to communicate about concerns both ways.
Yeah, I agree. Well, thank you again for joining us, and please feel free, everyone who's listening, to reach out and just ask the questions you need to ask, and get on our calendar if you need to make sure you've got the right stuff in place, because that employee culture is so important to the success of the business. I mean, if you neglect that, everything else falls apart, and you could even expose yourself to undue lawsuits, harassment, and everything else just because communication and the culture was obviously based on something that wasn't healthy. So, Lynn, thank you so much for adding to the podcast. But is there one thing right now that you find that people are struggling with when it comes to their tax planning that is there one thing right now that you can think of to pass on to somebody, maybe even from our interview, or something about taxes? You're always someone good to summarize what we've been talking about.
Well, since you said tax planning,
yes.
and we're
not
airing this, but we're filming this on April 4th.
Yes.
I'm thinking, don't be afraid to file an extension and give yourself an extra 6 months to get it all done.
Hallelujah. Yeah. Hallelujah, there is that law.
And the benefit is always that whether this is the airing after tax deadline or not, and hopefully you file an extension if you're seeing this after the fact, but it's about having regular ongoing tax planning meetings with your CPA, which is something that Killingsworth Spencer specializes in, and it goes a long way to just doing the right things from an employer standpoint, having that team behind you. So thank you both for joining us today. Of course, my name is Corbin Cook, S&B Strategy Consultants, where we help business owners clarify the financials. And I like to say it's like swimming in the Caribbean versus swimming in the Atlantic. When you actually know what your numbers are and you know how to achieve break-even and profitability and move your dials, it changes the entire game. So feel free to reach out to all of us as part of your team here. Thank you so much. Have a great week.